Welcome to PM Express. It's a conversation that has led to chaos on our streets, very close to the seat of government, the Jubilee House. It's about the fight to expand access to legal education in the country. Students have been protesting this week, asking that government intervenes to get the General Legal Council to accede to their demands of expanding access, especially when it comes to first entering the Ghana School of Law and also sitting the bar. So really, the Attorney General's department or office is, some say, is the government that might be very instrumental in representing these concerns at the level of the General Legal Council. Today, the presidency released its own letter that had been sent to the Chief Justice, asking the General Legal Council, asking the General Legal Council to do something about the concerns of the students. I am delighted to say that I'm joined tonight by the Deputy Attorney General, Godfred Yeboadame. Godfred, thank you for your time.
Thank you very much. Welcome to my office.
Let's start with, I started by talking about the protest this
Right.
week. You've been a law student before.
Yes.
Have you witnessed this before, where students, law students, hit the streets the way they did in 10, very chaotic?
I think it's unprecedented in the history of the nation. Has never occurred before, and for me it was quite surprising. But of course, we live in unusual times, and I think that the reason why it occurred previously was because of the very nature of legal education. Because legal education is essentially to train the person ultimately to become a lawyer. One fundamental thing in the practice of a lawyer, in all the various requirements to be a judge, whether at the lower court or the Superior Court of Judicature, is that a person has to be of good character and moral integrity. So that requirement for a person, definitely a lawyer, to be of good character and high moral integrity, have in a way prevented lawyers from demonstrating. And because lawyers are not known to demonstrating, law students have also, by nature, refrained from demonstrating. I mean, it is not unlawful to demonstrate, save that, as I said, because of the rigorous demands of law, legal education, legal training, and the fact that you are required to be a lawyer, and that society the whole society looks up to you for guidance and training. I mean, it's unusual for a law student to be demonstrating. Whatever grievance is usually dealt with through the manner in which we know best, that is to argue. So the form of a petition to your the regulators of your program and to the General Legal Council or even Board of Legal Education, and that's it. So when back in the days when we were law students, and of course there were even some concerns about the introduction of payment of school fees. It was in our time that school fees were actually introduced for the first time, and I remember it was about 25 million cedis or so. And some of us, by virtue, by stroke of fortune, were able to have gone on holidays and abroad and come back with some money to be able to pay, and actually paid it out of my own funds. I was not privileged, contrary to the statement made by some students today, that we want to make the law profession privileged. No, some of us came from less privileged backgrounds, but of course, we were able to go through, and indeed when there was the first requirement for us to pay school fees, as I said, I paid out of my own funds. And we had to negotiate for a reduction of the fees. We made petitions to the then Director of Ghana Law School, Professor Mr. Ansasari, and then I think the amount was reduced from 5 million to 2.5 million. Oh, I did not think that was reduced, but it was actually split so that you could pay 2.5 million or 25 million the first part of the course, and then 25 million. That's exactly how it is.
So the demonstration was unprecedented.
Yes, unprecedented.
It wasn't only that, it turned chaotic and
Yeah.
violent to the point.
Yes.
You were actually caught up in it.
Yes.
Here at the
Yes.
Department of
Yes.
Justice.
Yes. And I find the occurrence of any brutality quite unfortunate and most regrettable. And I think that perhaps the manner in which it was handled left much to be desired.
I mean by the police?
By the police and all. Of course, I was not witness to the incident there because it occurred after the protesters.
So you have a taste of it?
Yes, I'll come to that. Protesters had left the precincts of the ministries, and I learned going to Akwaji. So I was coming to work. I attended a meeting in the morning. So around 10 o'clock, I was driving to the office. And then I ran into the protesters, literally. And indeed, I could have actually gone through unrecognized. Because, well, I'm sure many vehicles had gone through and that they had paved way and all. But as concerned member of the legal profession, I decided to slow down. And of course, in jest, I actually beckoned the demonstration, who I thought was the SRC president. And indeed, I was right. I beckoned to him and asked him to come over. And he took me, I said, in pidgin English. But the person who will play a role in the restoration of your grievance, preventing him from accessing his office. Anyway, so immediately he recognized, oh, Deputy Attorney. So he actually obliged my request and went and told his people to pave way. And then the protester said, no way. I mean, the Deputy Attorney General, no, so we must address us. So I said, okay, it's not a problem at all. And then I recognized Bernard Muna, also a friend of mine. So I also, again, told Bernard, I shouted, Bernard, and he heard it. So Bernard Muna came over, and I told Bernard Muna that I can naturally play a role in the resolution of whatever grievance. So just let me have access to my office, and then attend to it. So they'd actually been there, and they had shouted, and nobody had come out. And I said, well, for how long? About 30 minutes or so. And that so they said they had presented a petition to the Attorney General. I said, so if indeed nobody came out, were you able to present the petition? Then they said, oh, to the office. Present the petition to the office. I said, okay, no problem. So just let me go. The petition has been delivered to the Attorney General. Definitely it will receive attention, and we'll deal with it. And then he said, no, they wanted me to address them necessarily. So I told my driver, but they had actually surrounded the vehicle at that time. They sat on the bonnet, so they beating the vehicle and punching and the bonnet and drumming on it literally and demanding. So I told my driver, no, let me address them, it's okay. So it was Bernard Muna who advised me not to get down. I'm sure it was good advice, with the benefit of hindsight. So, because obviously, if I had gotten down, I don't know how enraged they were, and I'm sure it would have been another story. So I sat in my vehicle, and I took the microphone, addressed them. I saw the cameras and all the other microphones, including the ones from your station and sister station. And I told them that, well, the issue of legal education, as far as I'm concerned, needed. We ought to attend to it. There has to be a comprehensive examination of the issue. And that I'm happy the petition has been delivered, it will receive attention, that kind of thing. Then, still wouldn't allow me. So they actually prevented me from going through. But I was not bothered at all because I've been a student before. I was in Commonwealth, or we do demonstrations. We were never afraid of demonstrations at all. And I was also the leader of AFAC, Alliance for Accountable Governance. I did a demonstration in 2009, about 3 demonstrations or so, together with other persons who are members of parliament now, Dr. Friye and the rest, from Samuel Oku and all, from Circle, right to the ministries and even to parliament and other places. So I was actually enjoying. I had to use another route. I turned back, went out through the gender ministry area, came back through Kempiski, Richard, and back through the conference center, and then the Ministry of Education area, and I entered. I realized that indeed, after my address, they were satisfied, or they seemed to be satisfied, and they were leaving. So they started leaving. And after perhaps I had left the scene, they became satisfied, and then they left. So I actually saw their bags, and I was able to drive to my office.
But some people accuse you of you being the person who called the police, and that you had refused to speak to them, and you say that's not true.
Ridiculous, absolutely untrue, because the whole event was actually captured, was filmed. One law student, friend of mine, who was not there, actually said, "Oh, I did vote," and asked how were you able to tell? I said, "Oh, but we watched it live. How were you able to watch it live?" I said, "Oh, it's something called Facebook Live or so." I am not on Facebook, so I do not know. But he said it was booked live and all that, and they watched how everything. So it was captured. And I think even UTV, later in the day, I watched UTV capture about 5 minutes of it. So there was no way I would have called the police people to meet out the politics and whatever. And nothing at all happened at the ministries. So the incident in question, as we all know, happened after they had left the ministries at Akweji intersection, as they say. So I don't know what might have triggered there.
Subsequent him, but I've seen the pictures. You condemn the actions?
Yes, I think that was a little...
As somebody who used to lead the Alliance for Country.
Yeah, clearly. I think...
But that's where I got to know you.
Yes,
As some say, as a Jean provocateur.
Yes, no, as an activist. And yes, for advocacy of rights and that kind of thing.
So you definitely condemn that?
Yes, I think it was high-handed. And I think that if they had handled it perhaps in the manner in which I had done so, I addressed them calmly. At that time, the police, it was at that time that the police officer, I'm sure they got scared by how the vehicle had been surrounded, and so perhaps word had gone out already, and then they came. So, and at that time, they were even trying to force them to open up. I said, no, they shouldn't open up. It's okay. Just 5 minutes, and I'll get back to my office through another route. So I think that sometimes there's a need for reasonableness. There's a need for us to be a little bit tempered in the way we react to certain situations. Certain situations do not require... After all, these are law students. And law students, how harmful can they be? They can only be over-enthusiastic and over-exuberant in the expression of their views and all. And as I said, even though it was unusual, has never happened before in the country, I do not think that it's something that should not be entertained at all.
What is it that the Attorney General's Department is doing about these concerns that they've consistently been put in before your good office?
Right. I think the position of the Attorney General now, or the actions that have been taken by the Office of Attorney General, are clearly conveyed in a draft bill that has been presented to Parliament, which is still before Parliament.
Is it an amendment to the Legal Professions Act?
Yes, it is. It's an amendment to the Legal Professions Act of 1960 at 32. It's a Legal Profession Amendment Bill 2018, and it's still in Parliament. Now, that law seeks to recognize the need for an expansion to the LLB program, as well as expansion of access to the professional law course. And I say so because...
In what form, by the way?
Yes, enough for it. I'll come to that. Okay. So, indeed, it is first and most important to recognize that legal education everywhere in the world is regulated on account of 3 principles. First is the legal system that the country deploys, or legal system that the country resorts to. Second is a requirement for higher education in the specific country in question. And the third is the requirements of the legal profession itself in the country. So those are the legal education is run and reformed from time to time. In the United States, between 1968 up to 1991, at least I have documents to that effect, records to that effect, there was an expansion threefold, 3 times, the size of lawyers who were turned out in 1968 were produced in 1991. Now, so the Attorney General, in recognition of the fact that, in recognition of the expansion of population, in recognition of the enhancement in interest in people to pursue law, legitimate as it is, has come up with a bill which is before Parliament. And that bill seeks to establish or allocate what we call quotas to recognize universities. Because the original bill, the original act, at 32, Legal Council with the power of approving universities to run law courses. That is it. Now, but if power is there, you find the General Legal Council has been quite relaxed about its implementation. So, as a matter of fact, there has been a less strict enforcement of that provision, to the extent that I do not think that the General Legal Council has actually cracked the whip in the sense of disapproving a specific university from running an LLB program. So indeed, all universities, most universities run the LLB programs, and they're allowed, and the products come out, and then they, as the young man would say, gate crash the law school because there's limited space. Now, if, as the Attorney General has proposed in the bill, there is the allocation of those quotas, it will require that, it will necessarily imply that, say, University A will get a quota of about 60 students, depending on the size of the faculty, depending on the pressure on the university in terms of access, in terms of application to run the LB program. So you find that ultimately, as a result of the allocation of those quotas, a higher number of students will be churned out and who will be qualified for admission to the law school. Then also comes the practical.
Is that the case though? Because the quota, that is actually limiting.
No, it's not limiting. It's
cannot go.
No, it's a misconstruction. And again, that is why. Okay, I'm coming.
Those quotas by themselves are limited.
No, but it's that
in number.
Okay, excuse me. I'm saying that. So, if the quota is understood within the context of the ordinary way, like say, WTO quota, for instance, then you construe it this way. But I'm saying that, indeed, because hitherto, the manner in which law school admission was run was that the General Legal Council will conduct an examination, then there would also be an interview, which has been scrapped now, and a certain limit on the spaces available, granted. So if the council determines that for the law school we have only about 100 or 150 spaces this year, that's a of students that are sitting for the LLB examination in the various universities. It is still the same 150 spaces that they have to fight for. But now the law will enjoy that regardless of that opportunity, there will be the allocation of these quotas to these specific universities, the universities that will be recognized to run the LLB program.
Bearing in mind the limitations at the law school.
Bearing in mind the limitations at the law school. No, but I'm coming. So I think, well, but even then, I told you, the practical measures that have been taken to ensure that indeed all the numbers that will be produced as a result of the allocation of the quotas will have admission to law school.
Okay.
Is that even last year, a committee was set up by the General Legal Council to explore means of getting more space, physical space, for law school. And actually, they went around the various universities. GIMPA specifically approved of a space to accommodate training of lawyers.
This is a professional.
Yes, professional law course. Professional law course.
This is a Mokola.
Yes, Mokola. So expansion.
This is moving
so
towards
already
decentralizing Mokola. Is that what you're saying?
Already there has been decentralization. I mean, there are 3 campuses of the law school: the Kumasi campus, the Accra campus, that's the Mokola one, and then also the Legon campus, which is actually now being housed at GIMPA. But in addition to that, I'm saying that there was the search for, and there was actually the obtaining of spaces, various universities. And I can cite GIMPA as a specific example of a university which actually granted more facilities, more buildings for law students to be undertaking their training.
Is it faculty?
Yeah, no, that's for the law school professional law course, to ensure that there will be greater access to the law school after persons have studied for and obtained their Bachelor of Laws certificate.
Okay, so GIMPA and Co will be given the space for that. That hasn't happened yet. It
happened.
It's happened.
It happened, and unfortunately, 128 students, only 128 students passed the examination. So the issue this year must be examined within a particular context in which it occurred. And the issue was that only 120 students actually passed. It's as simple as that. So indeed, the space. Simple as that. The space.
That is a GBA's position.
Yes.
Position
yes,
as well.
and authoritatively, I can say that indeed, if 1,000 students had passed today, had passed this year, they would have gained access to the law school, because indeed there had been provision, there had been fiscal provision for that.
As we said now, do we know, in terms of numbers, the space that was available?
1,000, at least 1,000, yes, because actually they prepared in that manner. Yes, so
there were 1,000 places.
Yes.
Well, is this the first time in a long time that number of spaces have been available?
Clearly, so.
For Mokola?
Yes, because they anticipated.
Of the decentralization in KNUST and also on Game Park campus?
No, because of the realization that indeed over 1,000 students will be writing the LLB examinations, and that was possible that 1,000 students will pass and will have to be admitted to a law school.
But for the first time, you're saying spaces have been made in
provision
locations other than Mokola?
Yes, other than Mokola, other than the Legon campus or law school, which is at Gimpa, as well as other than the Tech, the Kumasi campus.
Now you had a place at Gimpa,
yes,
Gimpa as well.
Yes.
So this is purely a case of students not meeting the standards.
Precisely, simple. And I think that fact ought to recognize this. So the problem must be examined. So it's not a case where you could say that the law school had only 120 places for law students this year. It is not so at all. It was not a question of the law school placing a cap or placing a limitation of 128.
So this isn't the case of no space?
Definitely not this year, definitely not.
You had 1,000
spaces. Yes,
students were simply not good enough.
It's a case of
take up the 1,000.
Precisely. It was a case of only 10% passing. But I would say that this is also not unusual. It is not the first time in the history of the nation that indeed persons applying to pursue professional law course, you have had such a low. You know why? You know why I say so? Yeah. Because in our time, there was a private program run for those who had not pursued undergraduate LLB. After the pursuit of other professions and occupations, decided to apply. They call it PLC, the preliminary law course. So that stream of students would pursue a 2-year course to the at the law school, and then they will join the graduates of the LLB program from Legon. So we have many of them, very good students. Some of them very good. Professor Atefa, I think he will join, or maybe no, he had come from abroad. And there's very good students. One very good lawyer, or Serusu, very my mate of mine from a Kufadu Pempen. We're all part of the PLC. In their time, less than 10% of the students passed, and there was no hue and cry.
No,
over that. So I think that is not unusual.
Isn't that an abject indictment of the system that trained the students? If
no,
they were poor, they were so poor that only 10% passed it.
No, so I think that first and foremost, I would like to actually examine it in the context of how lawyers all over the world are trained, for us to see whether there is any unfairness. And I'm saying that every trains its lawyers based on these 3 principles: the legal system that the country adopts, the requirements for higher education, and the requirements of the legal profession. So, and in most countries, advanced countries, always undertake a proper evaluation of the requirements of the legal profession, because really the advanced countries will not want a situation where they will unleash so many students onto the market and who would ultimately not find employment, because that will actually increase unemployment rate. Now, United States of America, how are lawyers trained? The manner of training of lawyers in the United States of America, and that is why law training in the United States is essentially postgraduate.
Yeah.
It's postgraduate. You first undertake a course in any field at all, because there's understanding, there's their concept.
We have here too.
No, it's both. I mean, so there's a fusion of both.
Okay.
So the United States recognizes in principle that law must be studied only after the pursuit of a course in any field of endeavor. And then after that, they do what we call the LSAT as a requirement for a postgraduate course. And the LSAT is actually so rigorous and intensive that only about maybe 40% or 30% pass. Do the point. And so that LSAT process is a way of refining the materials who ultimately will be admitted to the pursuit of LLB program, because it's postgraduate, or some other master's program that we want to do. So after the LSAT, then they pursue the 3-year course that they call Juris Doctor. And after the successful completion of the Juris Doctor, then they write the bar examination.
Anywhere? All
Yes, but yes.
So decentralized.
So after after the successful sitting for the bar examination, then you undertake what we call some practical training, which we will term as preparation. Then you are qualified.
You brought up the American example.
Right.
One of the calls that the students have made is that we replicate that here, where every tertiary institution in this country, once accredited, can allow students to sit for the bar. You don't have to go to Mokola necessarily.
Yes, but the American system is not necessarily pursued by every civilized country in the world, and I think that in the search for solutions to the problem, we must also be on guard against adopting easy measures just for the sake of it, or adopting easy measures just to ensure a widening of access to the professional law course, or even for number of persons who will be qualifying as lawyers. And I say so because, indeed, the American system, if you take a critical look at it, it will require that before you become a lawyer, you would have had at least 7 years of theoretical training. And that's because you have your undergraduate one, 4 years, and then after that, you go out and come and sit for the LSAT. And I've told you that the LSAT is about 30%. And even the America, it's also important to note that America accredits universities to run LLB programs. So of all the 5,000 or 10,000 or perhaps even 20,000 universities in America, it's only about 200 accredited universities to run the LLB programs that exist.
So accredit as many universities as you
But that's exactly why we are saying that we have adopted it in part. So you'll find out that the measures that are being implemented through the new, or that are proposed to be implemented through the adoption of this legal profession amendment bill, will be the allocation of quotas to universities.
But not for the
I'm coming.
law course.
No, yes.
That's a faculty.
Yeah, because you see, we must also recognize that access to the LLB must be consistent with access to a professional law course, and that is one thing. That's one theory that I think that the proposed bill adopts, which I'm very happy
So to
by.
break it down, what you're saying is that you have to. This particular bill is looking at the end space constraints and
Match against
and matching it with the faculty training
ultimately.
and numbers.
Yes.
So that the number you produce from the faculty is guaranteed if the part are good enough
Ultimately.
to go in, because then the space will be that you're saying about. That's what you're doing.
Yes, and indeed, my personal view, as was conveyed at my vetting 2017, was exactly the same thing. That I think that access to professional law course must be consistent with access to LLB program, and also regulation of the professional law course must also be the same way as regulation of the LLB program.
I mean,
because otherwise you find this inconsistency and can feed the economy.
And you have a space for this,
clearly.
and then the problem
Also, even the quality that the professional law course will assure will clearly be absent from the kind of quality that product. Yes.
But students
and Kami, I think that you must assist me to properly convey the intent of the bill, so that people can understand it and will not rubbish it as
they have concerns.
But I'm saying so indeed, this bill seeks to say or recognize the principle that the General Legal Counsel or the regulator must be responsible for accrediting universities, essentially. Because as it is now, accreditation for the LLB program is not done by the General Legal Counsel. It is done by the National Accreditation Board. And that clearly does not take into account the requirements of the legal profession, as well as the legal system adopted in the country, which is Ghana. So we find these two principles which underpin the legal education in every country absent from accreditation of LLB. Yours, that effect. Then, and I'm saying that America is the same way, because America accredits universities to run the LLB programs. It's not every university in America that can run an IB program. So inherent in that American system is the regulation of universities and that kind of thing. So indeed, when the General Legal Council proposes through this bill to allocate quotas to certain approved universities or recognized universities, which is the old law said approved universities. The new bill seeks to use the language recognized universities. It's different.
The difference is this approval will be done by the GLC and not the accreditation board.
No, the old law actually enjoined that.
I'm talking about the amendment that you're seeking.
Yeah, but I'm saying both the old law and the new bill, approval and recognition, in that way, was to be done by the General Legal Council.
Okay.
But they've changed the word, the operative word. This one was approval. The new one will be recognized by the General Legal Council. So once that is done, you can be assured that indeed the products from that university will be of a certain standard. And there will be no questions about standard or whatever. And every university will necessarily have a quota of students. And in order to ensure that the quotas are of such number as will meet the demands of society, practically there have been measures put in place. And what are those practical measures? I earlier on alluded to the fact that there was actually the search for premises which could house about 1,000 students, and that's a matter of record.
For professional law training?
Professional law course. And that is contained in the report of a committee constituted by His Lordship Justice, chaired by His Lordship Justice Dochi, and another one chaired by, in fact, there were two search panels. One was chaired by Justice Dochi, and the other was chaired by His Lordship Justice Niebua. So all these and contain reports, and I think that the media can even apply for copies of that report.
So just now, to break it down,
so clearly,
I'll come to you. Just a clarity. So what you're saying, the report said in essence that break the monopoly of Mokola as a physical geographic location for training, and let other that
said absolutely privately. Indeed, that monopoly had been broken earlier on. I was actually a teacher in the Legon Ghana School of Law. I taught company law with Jogati from 2011 to about, in fact, to the time that I was appointed, and then I gave it up. So I practically experienced it. I was teaching at the Legon campus at Ghana School of Law. So it's not strange that. In addition to that, a very big expanse of land has been acquired at an area close to Presec Legon. That is for the development of what we call the Law Village.
What's that? What's the Law Village?
Yes, the Law Village is a very big place which can conveniently house thousands of law students. It's been an idea that has been in the works for a long time, in fact, more than 15 years. Now, in our time, there has been the advancement of the concept. The Attorney General has ensured that the General Legal Council fully moves the concept forward. The General Legal Council has started working on that, and I think there's even a signboard that has been put there. So it tells you that practical measures have been taken. And the law school, the law village, when completed, can have thousands of students.
You know what the
timelines are? I think that I would not be surprised if, definitely before the end of the second term of the President Nana Akufo-Addo, the law village will be in office.
4 or 5 years down the line.
No, I'm saying before the end. So I'm sure maybe in about 2 or 3 years, even into the term of Nana Akufo-Addo as president, you see it.
So this will operate in conjunction with other satellite campuses that will so train.
Definitely.
Professionals.
So I think that the question of physical space clearly catered for. Enough provision has been made for that. To put paid to the issue. Definitely not. I mean, gone are the days when
club for the privilege.
No, gone are the days when the Van Leer, Akufo-Addo, or no, I am Dami, Godfrey Dami. By God's grace, I'm Deputy Attorney General.
I do not think that manifestation of the new breed of privilege class.
No, not necessarily. Not at all. How? I mean
that the Chief Justice is so conservative.
No,
that he's simply protecting a turf for Godfrey Damis of this world.
Definitely not. And I'm saying that in terms of stock. Do you understand? So it is not a class. It cannot be at all. You have, I mean, come on. I'm sure there are many ministers that you do not even know in the law school.
Let's interrogate.
Yes.
And let's to the fundamental theme of it, which is the quota.
Right.
The students say to me, and this is tonight it came up, that is further restricting. Now they actually believe the GLC is spreading its tentacles through a restriction from the Mokola to the faculties. The faculties were previously, they could go in their numbers without any inhibition. Now, if you give an institution 50 people,
right,
and they have space even to take 100, their quota says 50. They say that is further restriction of.
Two responses. First response is that even the quotas that will be allocated, there is no guarantee that even a quarter or 1/5 of them will be met, because indeed that quota, it doesn't necessarily mean that necessarily we must admit 50 students from that school. They must pass an examination, just as we witnessed this year.
So the
there was.
also
I'm coming.
Exams?
No, I'm coming. I'm saying that this year there was provision for 1,000 students
for professional.
We admitted to the first year
Mokola.
of the professional law course. Be that as it may, we had only 128 students.
But because it's an
admitted.
entrance exam. But the faculties don't have entrance.
No, but hitherto, even our time, you necessarily have to pass certain courses before. If you don't pass those courses, how can you gain access to the
I mean, if
program?
I'm going to GIMPA, for example, for the faculty, for the 3 years training that they do now, I don't need any entrance exams in the end.
No, but the new bill, I mean, unless Parliament amends it, after the successful completion of an LLB program, you need to do an examination.
Before you can enter the faculty?
Yes, yes, from memory
but
serves
that
right.
is further restriction
No,
of the space.
no. You see, so I cite the example. No, I'm coming. No, Evans. The life of a student now.
Many examinations to
The
enter
life item for examination is incompatible.
No, I mean,
I do not think so. I think that
into school
I think that
should be given to everybody. Then you sift through it.
Okay.
At the exams
I am saying that even
itself.
if the law is being, it will go through process of refinement. The drafting of the Office of the Special Political Bill received countless amendments in the bill before it became law. So even if they were to do, Parliament is to do away with the requirement of an examination or interview, it will not change the situation, because definitely those students will have to pass specific courses set out in the statute, compulsory courses to do.
We should now want to introduce in this bill.
So it's been there. It's in the act. So I'm saying the league, you see, I think properly itself before interrogating the subject.
Why we have
Because
this
it's
conversation.
good, because the proper, just give me 2 minutes for me to expand on this one. The General Legal Council had the power to approve universities for the running of LLB programs. It is there, it's in the law. So this situation whereby National Accreditation Board will accredit universities or whatever was even unlawful. But because the General Legal Council had that liberal attitude and approach, and of course recognizing the need for law, they were not even cracking the whip. It doesn't mean that the law obligates to the law, but that is the law. Since 1960, it has always been there. Another point too, as I indicated to you, is that indeed, even in America itself, there's some sort of regulation of universities which run, are accredited to run the LLB program. Is there? I mean, the Jewish doctor, as they call it. It's only about 200 of all the thousands of universities in the whole of America, big America, which are authorized to run programs designated as qualify you to write the bar examination. So it has to be done.
Today, just tonight, I spoke to the chairman and the ranking on the Constitutional, Legal and Parliamentary Affairs Committee.
Right.
The committee sees with this particular
yes.
The chairman, who is from your own side,
Yes.
Ben Abdullah, says personally he's against this particular amendment. The ranking, who was also on the line, Mr. Husseini, I'm sure is a good friend of yours, also says he's opposed to the amendments as proposed. that clearly tells you that you don't have the support. Something must be wrong with that particular amendment you're proposing.
Well, I think, first of all, it stems from a misunderstanding of the whole concept of quota. And even at the outset of this program. Well, I agree.
They've done this job for a while.
Yes, they're all very good friends of mine, Honorable Banda, very helpful and all that. But in any case,
surely can't say they misunderstand the bill.
No, because the bills will emanate from the Attorney General's Department and laid before the body seized with passing of bills and laws in the country, and that's Parliament. And of course, they have the prerogative of making any amendment to the bill. So rather than tearing it up as if it's an act and binding on the nation, we ought to properly interrogate and find other means which will improve the state of the law as it is now.
But you certainly believe that your proposal on the table is a non-starter.
Well, but I'm saying that even the Office of Special Prosecutor Act, the bill when it was sent, went through a process, hundreds of amendments by even members on our side and members on the other side of the
so
NDC.
You're saying this is not
so
by
definitely not. It's a bill. That's why it's built.
Reserves the right to change it.
Definitely.
Are you ready to forgo the quota?
Yes.
So that's the key thing they object to.
Yes, but I'm saying that we are prepared to adopt any approach which will enhance access to the law school, because indeed there has been practical provision for greater number of law students.
I hear you say expand access.
Expand access. I mean, enhance, expand, increase. I mean, as far as I'm concerned, they are synonyms. But of course, you could adopt a view.
Enhance is more about the quality side of it. The access is about expanding access is about
I said enhance access to the law school.
Enhance access.
So clearly, is the increase in physical access that I'm talking about here. And of course, it's also important to indicate that standards cannot be lowered. That is a fact. That is where, even where there has been physical provision of space for law students, there will still have to be the institution of standards. Examinations have to be written. Examinations have to be passed. I do not think that is appropriate for law students to expect that they ought to be dispensing with the requirement to write examination. It cannot be at all. And that's why I prepare to readily entertain other concerns of as the amount that they've indicated.
The 3,000.
The 3,000 that they said is too much. I agree. Yes, because I'm a human rights person. I'm a human rights advocate all my life. If you
feel one paper, you have to write the entire court.
Economic circumstances do not have to be in your way to becoming a lawyer. And if indeed you feel that there's just cause for a review of your marks, and financial circumstances cannot be an impediment, has reviewed. In our time, as I said, Dami from Brownful, when she who wanted to study law, yes, when there was a requirement for payment of fees, I was SRC General Secretary at that time. I led the effort in recommending to Mr. Sasai to either reduce the fees or to split it. And Mr. Sasai offered to, I think, split it, and that's what he did. Because he's a little bit capitalist in his thinking. And that's why it's a little bit ironical that at this time, he's rather talking about
expanding it.
Just not just expanding, but uninhibited or unrestrained access to a program. And you do not find that anywhere at all. Even for accountants, chartered accountants, it's very pertinent to note that yes, the sit examinations and the examinations are written, assessed by persons who are not necessarily those who taught the students. There's a board of examinations. Even for medical students, you know, they undergo a process of studying, theoretical study, for 6 years. And then, after the pursuit of their theoretical studies, they come and do what they call housemanship. And that's for 2 years. My wife was my mate at law school, University of Ghana, but ended up being qualified a year after, because theirs was 6 years, ours was 5 years, 2004. But then she was awarded with only an interim certificate. It was after the pursuit of her housemanship that she became a fully qualified doctor and was awarded a substantive certificate to practice. So that will actually ensure that you stay in training for 8 years. Now, so if the law school now is run in such a way that you pursue the theoretical training, which is made up of you understanding the principles of the law and what the policy of the law, and for 3 years, and then you go to the law school, which is the inculcation of practical vocational training. You have courses like advocacy, evidence, criminal procedure, civil procedure, and what have you, just for 2 years. And then you come out and you are a lawyer. And then now there's this new bill. The new bill also ensures that you increase the pupillage from 6 months to 1 year. And then you pursue pupillage for 1 year, and then you are accorded what we call awarded the certificate solicitors licenses. I think that is fairly reasonable in terms of the arrangement that have been made. So indeed, I find it a little bit unreasonable and absurd when the students even take an aim at the examination committee. I thought that it's supposed to assure integrity. I thought that the institution of an independent examination committee is to assure that indeed your examination will be marked by persons who do not have any biased stories. It's to assure impartiality and fairness and enhance fairness. And as law students, they should not be interested in any measure which will restrict fairness or inhibit fairness. And I've made the point today that if it's about fiscal access, really there has been allocation of fiscal space. There has been the identification of space at Gimpa and other places which will ensure that 1,000 students are admitted every year. Their only requirement is for them to pass. After that, there will also be the development of the law village. And I'm very hopeful and sure that it will come to reality in the final, before the conclusion of the final year of the Nadu Dakwa, that the second term of the Nadu Dakwa Kufuor as president.
That's it for PM Express tonight. A big thanks to the Deputy Attorney General who's opened up, given us a lot about the process towards dealing with the concerns that the students have raised over the last few days, and in fact many say over many months. He believes there's a lot of progress being made in dealing with this side of law, through policy to administrative interventions such as he's just disclosed to us that the GLC itself has done with the committee that was set up. Grateful to him for that. My name is Evans Mens. Enjoy the rest of your evening.